Good afternoon, everyone, and welcome to this workshop organized by the International Law Association, the Nigerian branch. Can I ask everyone to please mute your microphone as we'll start, so we don't have interruptions? Thank you. On behalf of the Executive Council of the branch, it is my greatest pleasure to welcome you to this event. The main aim of today's event is to discuss the key implications of the ongoing pandemic for international law, for the practice and study of international law, especially the key implications of those developments for those of us that are international law practitioners or those that aspire to be. I am Professor Damilola Olawi. I am the Vice President of the Nigerian Association. And in a short while, you will be hearing from the President of the branch, Professor Fidelis Odita, Senior Advocate of Nigeria, and Queen's Counsel. And also today, with our committee in planning the event, we're very fortunate to be able to secure the participation of a number of very senior practitioners and scholars who you'll be hearing from shortly. But before I start, I thought I should talk about the ILA, just to give you a little bit of background for those that will want to join us. The International Law Association is a leading association for the practice and study of international law. While a lot of people say, what is the difference between IBA and ILA? While the IBA, International Bar Association, is mainly for practicing lawyers, the ILA focuses more on the study of international law. So it is mainly made up of jurists, scholars, researchers, academics, and of course, practitioners as well, who are interested in the study of international law. The objective of the ILA is the study and clarification of international law. And of course, the Nigerian branch, which is one of the newest branches of the association, was established in 2014 with the president being Professor Odita, Queen's Counsel Senior Advocate. And the branch was inaugurated by the Chief Justice of Nigeria at a public ceremony in 2014. So over the last 6 years, we've been trying to promote the study of international law, and many of our members are senior practitioners, either in law firms or academics, or academia rather, or in government, or some. We also have even non-lawyers who are in public service or in industrial and financial spheres. Special thanks to the team that put together this event. Special thanks to members of the ICT team and to all other members. I will just pass the mic to the president of the branch, Professor Fidelis Odita, Queen's Counsel Senior Advocate, to give his welcome address.
May I add to the welcome that you have extended to the participants at today's ILA webinar. The ILA is the study, clarification, and development of international law. And I'm very excited that we are looking at the impact of the current pandemic, international law, and foreign relations. And we're grateful and indeed very excited today to have as our keynote speaker Professor Obiora Okafor, who is a UN expert on human rights. And we also have very distinguished panelists, Dr. Femi Elias, my very good friend from Oxford of over 30 years. We've got a very distinguished panel of discussants, Dr. Femi Elias, my friend, Ms. Amoteshe Eva, and Mr. Yusuf Damadani, who will be discussing the presentation to be made imminently by Professor Obiora Okafor who is a UN expert on human rights and international solidarity, as well as a professor and York Research Chair in International and Transnational Legal Studies at Osgoode Hall Law School in Canada. Professor Obiora, I welcome you to this webinar. Without holding up the program, the next item on our agenda is a keynote lecture by Professor Obiora. Perhaps, Professor Olawoye, you'd like to add a thing or two before Professor Obiora does his presentation.
Thank you very much, Prof. I think you said it all, so we'll allow the keynote speaker to take over. Thank you, sir.
Okay. Thank you so much, Professor Odita, Professor Olawoye, and the rest of the, I guess, executive or organizing committee for the invitation, which I very much appreciate. Thanks to everyone who made time to be here today. I don't have too much time, so I will. It's a very interesting topic and one that I could talk about for days, you know. But I have put together, perhaps I would say, a few nuggets, shall we say, about some of the what I call heightened challenges that the world and Nigeria will face, and I'm already beginning to face after, quote unquote, after, if it ever ends, and because of this pandemic. I will not have time to go through all of them, so I will look at perhaps three or so in some detail, and then I'll give a list at the end of some other issues that maybe perhaps the panelists would focus on. I don't have time to get in so much into the skills part. I'm very happy that Dr. Elias is here. Mr. Yusuf Damadami, the legal advisor, are people who are real practitioners. I just dabble into practice from time to time. I'm a scholar. So let me go straight, having said that, let me go straight into the presentation. So the first, I just want to give you a sense of the outline. The first thing I want to talk about is the fact that the challenge of international solidarity and cooperation that has always been there will heighten post this pandemic and because of this pandemic. There will be also a challenge around equitable global access to any vaccine, COVID-19 vaccine that anyone is able to develop. And there'll be issues around international trade, debt over accumulation and relief, and so on. And these are issues that will arise or heighten, mostly because the global economy is going to be devastated, more or less. There's going to be, and there already is a serious economic downturn. Those issues will heighten in the result. All right. But first, a few introductory words. What I'm going to do here is mostly provide a conceptual overview. Like I said, there's not so much time to get into granular detail. The next thing is another general point is I want to emphasize that international law and actually foreign relations are both quote unquote disciplines of crisis. They sort of thrive on crisis, and over the long durée, the longer arc of time, that is how they have developed in sort of fits and starts and jumps after and because of crisis. So, so in the first sense, these disciplines they're very related, have been historically shaped by crisis, and so nothing new really in that sense. And also related to that or connected to that is the fact that we as students and practitioners love to focus on crisis as we're doing today. And there's nothing wrong with that as well. We revel in a good crisis. It gives us an opportunity to focus our minds on how we might perhaps improve. For the most part, some actually don't want to improve it, but how we might improve the system and develop it. And it also gives us a sense of our own relevance as practitioners and academics or students of the discipline. Yet, it's important to emphasize that history hardly ever ruptures into two, right? So there is hardly a before and after that is neat, right? So the past is connected to the future. Continuity is more present than discontinuity. That already we live in a world in which many of those challenges are already acute, right? So problems of economic downturn, mass poverty, a lack of adequate healthcare access to healthcare, unfair terms of trade, inability for almost everyone in the world, other than a tiny percentage, to move around the world freely, and so on and so forth. So the challenges that I'll talk about are actually existing challenges, but which might become exacerbated or renewed or heightened in some way after and because of this COVID-19 crisis. So my point was that the first challenge I want to talk about is the challenge of enjoying international solidarity, if you want to put it that way. This is not just a moral question, because I often face this question whenever I talk about international solidarity. It's not just a matter of charity. It's a challenge, of course, that exists today. It's already acute in terms of the lack of international solidarity or lack of adequate international solidarity, which includes cooperation. I don't have time to get into all the definitions and all that, but just to illustrate with, for example, the explosion in Lebanon, there's an issue of preventing it, working together as an international community to prevent such things, reacting to it, as you see the international community coming together, and cooperation in terms of the necessary steps and measures you take to do either the prevention or the reaction. So I just want to say that because of the pandemic, these challenge of cooperation and solidarity will heighten. Post-pandemic, we are reminded, perhaps even because of the pandemic, of our mutual vulnerability, our deep interconnectedness as human societies, the fact that this pandemic will never end for any society until it ends for every society, it sort of illustrates that point. I'm moving rather quickly. I could talk about sort of the more legal foundations of the duty to cooperate. You can go to, for example, in the human rights field, you can go to Articles 55 and 56 of the UN Charter itself, the Convention to Combat Desertification, even the Law of the Sea, and so on. But I don't have time to get into the detail. If there's time, we can talk about it in conversation. But the next is a challenge that I want to highlight today, which will be it's an immediate one, and it will be an acute one, is the challenge of providing equitable access to a COVID-19 vaccine. If one, and I think one will be developed when, and if it is developed, there will be a challenge of solidarity. Now, the question here as international lawyers is there a legal regime that is relevant, or are there legal regimes that are relevant? The first place you might go to are the International Health Regulations of 2005, which 196 states, both WHO states and non-WHO states, have adopted and ratified, and which impose a global regime to detect, assess, and report public health events. But these regulations do not deal with this challenge of how do you provide equitable access across the globe to a possible vaccine. that issue is not dealt with in the health regulations. However, this question is closely related to something that has happened at the intersection of trade law and international health law and intellectual property law for a long time, actually, since 2001. And I'm talking about the Doha Ministerial, right? The Doha Ministerial Declaration on TRIPS, the trade-related aspects of intellectual property rights under the WTO framework. You will all recall that this agreement, which is a 2001 agreement, shall we say, emphasized the flexibilities that are available already in TRIPS itself to allow equitable access, global access to essential medicines, not just for HIV/AIDS or for malaria and other diseases, but for all essential medicines, okay? So, and I think this is important in the context of COVID-19 treatment or vaccine, right? This regime needs to be paid close attention. It allows compulsory licenses, not just for production and use of generic versions of medicines in the domestic market, but also for export to countries that don't have a pharmaceutical industry, which would be very important for most countries in the world. It also allows parallel importation measures to be imposed, for instance, and importantly, without the consent of the holder of the patent, right? So these are issues that would be very acute and very important, both during this pandemic and immediately after. Be essential, actually, to ending the pandemic. A subsequent 2005 WTO protocol introduced a new Article 31 bis, which came into force only 3 years ago, and kind of solidified and embeds this within the TRIPS treaty itself. So as I argue, this Doha regime should apply to any COVID-19 vaccine that is invented. That is my argument that I think that logically flows from the terms of those two protocols. Yet, even this Doha regime will not be nearly enough to ensure equitable access around the world. It is, as you see, is sort of limited to how do you get around patent protections and so on. That would not be all that is required. States or companies that invent vaccines or treatments may hoard, the sort of scientific data. They may not want to share, and some states are already saying so. Some states say they will share. Some states say if we invent it, we'll first take care of our own citizens. God knows how long that will take before we even think about sharing, and maybe they want to share it at excessive prices. So, and also takes time to manufacture vaccine doses and so on. So we need to start thinking about what kinds of agreements need to be reached, what kinds of regimes need to be reached, how do you sequence the rollout, and what role does law have to play in this kind of future? It's not even long; it's a very near future regime that we will require. Excuse me. So that's the first challenge that I want to highlight. International human rights law has something to say about it. I could talk all day about human rights, but I wouldn't today because of time constraints. And if there's a question, I can provide more material on this. Now, in terms of the next challenge, it's the challenge of more beneficial international trade regimes. Quite obviously, the pandemic has caused serious economic downturn, as I've mentioned, and these downturns are likely to be more acute in the poorer countries than they are in the richer countries, although, of course, the richer countries are also experiencing downturn. For example, Nigeria's GDP forecast for the second quarter fell significantly, of 2020 fell significantly as a result of the lockdown. Informal economy has been hard hit, unemployment has worsened, which was already bad. The Human Development Index, HDI, cannot be in a better shape. I don't have the exact figures yet. So in my own view, we require structural reform, and I emphasize structural. This is not new. Those of you who are trade lawyers, I am not, but those of you who are trade lawyers are familiar with some of the issues that have long been in play, that have long existed, that need attention, structural issues in the global economy. And why do you require structural reform of the global economy? We need to put more money in the hands of these poorer peoples, in these poorer societies, if they are to survive the coming economic downturn, and if the world as a whole is to benefit in the result. Of course, this requires serious national reforms as well, but I'm an international lawyer, so my focus today is on the international. But just to flag that, we need a more favorable global trade regime, especially for the global South. And two quick areas I want to highlight. We need to internationalize, streamline, simplify non-tariff barriers in global North countries, especially with regard to textiles. This is an area that global South countries could earn a lot of money from, for instance. And we need to reduce excessive global North protectionism, which continues to subsist in agriculture, despite the 2015 agreement to end export subsidies. Export subsidies are not they're a very small part of the agricultural support that developed countries provide to their farmers, to the disadvantage of farmers in the global South. If you are to have fair trade, then let's have fair trade on a global basis. So these are some of the things that we need to pay attention to. Needless to say, countries like Nigeria require many more highly skilled international trade lawyers than we currently have or produce. Those we have, most of them are abroad. Not that we can't utilize their services if they're abroad, but we need to really emphasize courses like this and train people. And I say this as an international human rights lawyer, I'm not even a trade lawyer, but we need, I see the need, great need in this. Every email I get of a student who wants to study international human rights, nobody wants to study trade. I'm exaggerating. There are some who are doing it, but we need a lot more expertise in these areas. We have to start realizing that we too now have international industries. Our banks are international. Our traders are international, foreign. Our creative and entertainment industries are international. Even our vehicle manufacturers now export their vehicles. So this is a very important area that we need to pay attention in a post-COVID world, especially in the context of the AFCFTA, the new Africa-wide free trade agreement. If we don't take care, for example, I don't know how many people in the audience know what rules of origin are, but if we don't take care, for example, with the agreement on rules of origin, Nigeria as the largest, by far the largest market on the continent. I don't want to say it using an American expletive, but is going to be put in a very bad situation. And what some EU country can make, say, cars in Rwanda and just flood the Nigerian market using the CFTA, for instance. The debt of undergraduate courses, they're all near total absence in our system of legal education. For example, ECOWAS law on African Union law should trouble all of us. We need to begin to train the new generation on these issues, trade issues, regional integration issues that are going to become extremely important in the coming world post-COVID. Debt accumulation, or shall I say over-accumulation, and relief. We tend to accumulate. Okay. Can you hear me now? I was muted for a while there.
Yes, we can hear you.
Okay.
Thank you.
All right. So my point about debt relief is that we tend to accumulate a lot of debt. Not necessarily a great thing. You do need, as a country, to accumulate debt. Every country has debt. But because we tend to over accumulate, we need skills in that area. We need skills. We saw those skills come into play to advantage in the first 7 years of this current democracy. We need lawyers who have those skills, not just economists who have skills. There's no established or standing international regimes in this area. They tend to be ad hoc around the IMF, World Bank, and so on. And once you say IMF, World Bank, you can almost surmise that they're not necessarily going to advantage you structurally or deeply. They're going to give you some advantage, but not a huge advantage. Don't take it from me. An OECD paper recently described the current debt relief measures as small, but significant temporary relief. So that's what you're going to keep getting if we have debt relief regimes that are embedded in the international financial institutions. Lawyers can begin to imagine alternative debt systems, especially regulating global, what I call global usury, excessive interest charges, vulture funds, for example, another issue that can be quite devastating to global South debtors. So we need lawyers with these kinds of skills in the world after the pandemic. Other issues, and I'll end with this. I'm just going to flag a few other issues that we need to pay attention to because I don't have much time. Of course, international human rights, which includes women's rights, we must emphasize. Issues around illicit financial flows, which Nigeria has championed at all UN levels, General Assembly, Human Rights Council, and so on. It's a very important issue, which contributes a lot to the net outflow of resources from developing countries to developed countries. International migration and movements, a huge issue, and this is connected to the international health regulations. For instance, we will need a new COVID-19 sort of yellow card or passports. Who knows, quote unquote passports, to even travel. These are interesting cutting-edge legal issues. Poverty alleviation under the soft regulatory framework of the SDGs, which has no accountability mechanism, by the way, but that's a whole other issue. And then the challenge posed to multilateralism by what I call reactionary populism. It's a very grave challenge. We've seen withdrawals from institutions like the Human Rights Council, from the World Health Organization. These do not conduce well to the survival of multilateralism. And imperfect as these institutions are, they provide a resource for weaker states that would not otherwise be available. They're actually good resources for weaker states to punch above their weight in the international system. So addressing each of these challenges will also require highly trained, or more or less specialized international expertise that we should seek to train and make available to the country. And I will just leave it at that and just say thank you very much for your attention and apologize for the rushed nature of the presentation. I did not have much time to develop it or expand it. Thank you.
Thank you. Thank you very much, Professor Okafor, for the very wonderful and insightful presentation. I totally agree that international law is shaped by crisis, and even the establishment of the United Nations itself was in a way, shaped by an attempt to end war and strife by countries. So whether we're going to get another body, a pandemic-related organization, or whether we will keep our faith with the World Health Organization, we will see how all of this will shape up. But I totally agree that we might need to be careful and not be too reactionary in our attempt to address the issues raised by the pandemic. Before we move on, I should acknowledge most respectfully the Vice Chancellor of Afe Babalola University, who is joining us. Given that we are using the facilities of the university, it's only logical that we say a big thank you to the Vice Chancellor, Professor Smaranda Olarinde, a professor of law who is online with us. We also have Professor Henry Ali Sigwe, the professor of law and dean of law at the University of the Gambia, joining us online. As we go on, I know some of the questions that will come up is what exactly do international lawyers do? Of course, other than working for the UN or World Bank or ECOWAS, what do international lawyers do? Or other than being Professor Okafor, whose mandate has just been renewed by the UN as an expert on human rights and solidarity, how can I become an international lawyer? And how can I develop my skills in this area? I know those are some of the questions that students joining us today will be hoping to get answers to. And we've assembled a panel of distinguished people who can speak to some of these issues, as well as sharing their thoughts on some of the key issues raised by Professor Okafor. Professor Fidelis Odita, QC, SAN, will moderate the discussion session, and I will leave it with him and the panelists now.
Thank you, Professor Lawi. And once again, I welcome those who have since joined us since I gave my initial welcome address. The first person that I would like to call on to discuss some of the issues raised by Professor Okafor is Dr. Olufemi Elias, who is the Registrar, UN Assistant Secretary General, and the UN International Residual Mechanism for Criminal Tribunals, and who many of you may know is currently Nigeria's candidate for election as a judge of the International Court of Justice. Femi Elias, I welcome you and invite you to make your own observations. I think each panelist has about 10 minutes to speak. Thank you.
Thank you very much, Professor Elisa. It's very nice to see you again. Yes, and thank you for your very nice introduction. I'd like to thank as well the executive committee of the Nigerian branch of the ILA, Professor Lawi, Mr. Agu, and all these other friends that I haven't seen in a long time. It's also a real pleasure to see my brother, Professor Okafor, again. Nice to see you. Very, very nice to be here. And thanks to everybody for coming and for listening. I would like to begin by thanking the Professor Okafor again for his very wide-ranging and insightful keynote address, which raises very, very many issues. As I was listening to him, I was modifying what I had to say, and to see how I could, try and take up some of the themes that he raised and what he mentioned. The first and most important, and obviously, very, very true thing that he pointed out, and which was taken up again by Professor Lawayi in rounding up, is the nature of the disciplines of international law and foreign relations. These, as he said, 100% accurately, are disciplines of crisis. Events happen, we respond, trying to address and look into the future and preventing those. Like you mentioned, the establishment of the United Nations as itself. After the Second World War, let's not do this again, peaceful settlement of disputes. While Professor Okafor took a broader view about what needs to be done, spoke a great deal about equal access to any vaccines that might come, substance of the law, the consequences that the pandemic might have, the importance of human rights and trade, and the substantive changes that need to be made to the rules in these areas. I thought I would look a little bit as you know, we're lawyers here, I thought I'd focus a little bit on what we have in terms of international law and international processes, and to see what impact the pandemic might have on that. Just like Professor Okafor was looking forward, as it were, I want to look a bit backwards to see what we have, to see exactly the extent to which some relevant rules of international law are fit for purpose and how the pandemic might lead us to different situations. Specifically, a group, again, I only have 10 minutes. A group of important rules here are those that relate to the fundamental principles of international law, arising from the law of treaties and the law of state responsibility. I think there are very many, a lot has been said, a lot has been written about many aspects of international law, but I want to focus on these a little bit. For instance, will this pandemic need us to rethink some of these fundamental foundational principles? As I said, there are many areas one could talk about. I'd like to talk very briefly about the circumstances precluding wrongfulness, the defenses that exist under the law of international responsibility, specifically force majeure in the performance of treaty and other international obligations, distress as an excuse or as a defense, and necessity and the scope of those obligations, of those defenses, as to whether they have any role here. It has been written, and it's something that's important, that the pandemic might force a rethink of some of these defenses. For instance, looking at the defense of force majeure under the International Law Commission's Articles of State Responsibility, Article 23, it's a very, very strict one. It's a very, very strict one. We all know, most legal regimes, when it comes to trying to get out of legal engagements, they will be scrutinized very strictly. But in the context of international responsibility, force majeure is particularly strict. And states have been very rarely successful in invoking it as a matter of international law. The COVID-19 situation might be an excuse for this, but because as it stands, states will have a great deal of difficulty in demonstrating the impossibility of performance that is required under the language of Article 23 as to force majeure being available to them. It's got to be impossibility of performance. We have a serious COVID situation on the one hand. It's very hard to find that any measures that states take as a matter of policy are the result of impossibility of performance when you have choices as to what measures to take, what regulations to impose. So that is something that might call for a rethink in the law of state responsibility. Similarly, necessity. Necessity might be more promising, might have more role to play in this context as a means of not being able to perform your obligations because of the pandemic. But there will still be some difficulties because, again, this plea of necessity for similar reasons is also interpreted in very, very strict terms by tribunals and by states. And they may struggle to prove that the measures in question were the only way, that the breach of the obligation was the only option available to states. That threshold is very, very high. Again, the pandemic might generate new thinking and new jurisprudence in this regard. They also have to prove that their behavior did not contribute in any way to the breach in question, to the problem complained of. Again, these standards are very, very high, and those defenses might be difficult. The plea of distress is a little bit, again, under Article 24 of the draft articles, is a little bit more promising because it talks about reasonableness of the conduct, unlike force majeure and necessity. The defense of distress allows states to talk about the reasonableness of the situation. So this may be a little bit more promising. These are all things that need to be looked at very, very seriously. Again, that's the law of state responsibility. That's important, very, very important in this context. Again, looking at the law of treaties, Article 61, 62 of the Vienna Convention on the Law of Treaties, or even provision on material breach, all deal with the consequences of supervening impossibility of performance or the right to suspend a treaty in particular treaty, when particular situations arise. Again, these have always been construed very narrowly as a matter of doctrine and a matter of jurisprudence. Again, it looks as if the pandemic may very well trigger a number of opportunities to rethink some of this and to give them actual life. So that is, I think that is one effect that this pandemic might have on some of the foundational rules of international law. And I think maybe that is one possibly beneficial effect that this might have, because being crisis of discipline is real cases that force what we do in future. But definitely there's no doubt that international law in this context and international organization are crucial. I think the roles of the WHO and the WTO are going to be crucial going forward. As the two previous speakers mentioned, maybe we will need a completely different entity to put these things into place, because of course questions of fairness and equity come into it, equality of resources in the world. But clearly, this is a very, very important thing. It is clear that any outcome any solution, any lasting solution to this crisis has to be taken at the international level. It has to be taken at the international level. The kind of problem we have here, as Professor Okafor mentioned, the solution for this pandemic is one that must be for everybody. For any country to be successful, every country has to be successful. Right? The boundaries don't mean very much. So the internationalization of the solution goes without saying. Of course, many countries are focused on ensuring the health and economic well-being of their own people. You have these international organizations, and their role is going to be crucial in solving this. So one understands the immediate reactions, driven partly by hard realities, maybe also driven by domestic politics, but these things are very, very important. The international effort needs to be coordinated. Particularly as international lawyers, as I mentioned, dispute settlement procedures will be very, very important here. Whether it's disputes that arise between countries concerning the repayment or restructuring of loan obligations among countries and enterprises. The entire range of international law subjects offers a framework for engagement and for resolving disagreements. In this context, one knows that there have been instances of allegations about discrimination in the use of COVID-19 national measures, which have already been referred to the World Trade Organization settlement mechanism for resolution. So it's important that it's necessary to minimize the exploitation of this pandemic as an excuse for far-reaching breaches of international obligations. Again, the role of international law is going to be crucial here, and there could be an opportunity here. This crisis could lead us in such ways to come up with rules, principles that are more fit for purpose than what we might have at the moment. Yes, equitable access. This is all things that have to be negotiated internationally. So I think I'll also stop there for now. All the structural reforms that Professor Obiora mentioned, fairness, equality, and trade, these are all things that international law is a language, because it's a basic template for any kind of cooperation in this respect. But I think international law is symbiotic. The international law responds to these and regulates them. And hopefully we'll have a new, more appropriate set of rules to deal with pandemics like given the nature of international law and international relations. And responsive disciplines that progress in times of crisis. For that reason, in terms of career-wise, I think the practice, my final word, the practice and the development of international diplomacy, international practice, it's more intense now. It's even more intense precisely because these are matters that require global cooperation to be resolved efficiently. I think that the consequence of this pandemic, again, to highlight the through various international organizations, through other means of relationship between states. But I think I will defer to two next speakers who I'm sure will have very, very direct and important perspectives in their daily work on the consequences of this for international practice. Thank you very much. I'll stop there for now.
Right. Thank you very much, Dr. Femi Elias, for a very insightful presentation. I know you're constrained by time, but you were able to touch on very many issues. I'm sure we'll come back to some of these during the question and answer time. The next speaker is Ms. Omotoshe Eva, who is a legal advisor, Federal Ministry of Foreign Affairs at Nigeria, Abuja, I beg your pardon. Are you online? I thought I saw you somewhere earlier.
Yeah.
If you are, please make your presentation. You've got 10 minutes. Yes.
Hello everybody. I hope I'm heard. I hope I'm being clearly heard.
I can hear you.
You can hear me? Good. I want to, first of all, thank you for this privilege to be here and interact with colleagues on these issues that are before us, post-COVID-19 and how it relates to international law right now. I am, by privilege, the legal advisor of Ministry of Foreign Affairs, actually from the Office of the Honorable Attorney General of the Federation and Minister of Justice. So, well, I'm very pleased with the issues that have been raised and want to really appreciate our keynote speaker because he actually touched on a lot of issues, even though his field is human rights, but he delved into trade and also the prospects of future international law post-COVID-19. Like we'd say, now everybody says the new normal. So we're trying to look at how we can fashion international law into the new normal. And I would like to probably look at maybe more of looking at it from the area of trade and investment, you know, considering the fact that globally, we're tied to each other by trade, by investments, and economically generally. So I wanted to probably lay a little more emphasis in my little time and see how we can, what we can look out for post-COVID-19. Now, knowing that our core principles of foreign policies are based on negotiations of bilateral and multilateral treaties. And most of these treaties are predicated on maybe principles of reciprocity. And then we're looking at how we can fashion. Hello? Can you hear me now?
Yes.
Okay, I was muted before. I didn't quite know that. I just saw it on my screen now.
No, we could hear you all along.
Oh, okay, but I just saw the mute that stated I was muted, okay. So like I said, basically how do we deal with investments, trade in this time? What do we do? Because right now, we'll be looking at, we should look at what could happen now that we have, with the with the post-COVID-19. And I would like to draw our mind to the fact that arbitrations may arise because of what happened due to the pandemic. This really is not anybody's fault. The pandemic came and it had stifled a lot of things. Now, we should also take note of the fact that investors may wish to claim for losses that they would have incurred in this season. So how do states deal with that aspect? It's something we should actually rummage over, something we should think about, because it's something, because we know that arbitration is not going to be helpful for states at this point in time. We know that awards are terrible. We know what even our country is going through right now with the awards we got from PNID. And you can imagine what will happen to other developing countries, because many developing countries actually opened their borders to investors, because most of us felt that foreign investors would literally be FDIs, foreign direct investments. And the investments are meant to what? Develop the economy of a state, develop a country. So many countries, especially developing countries, signed lopsided investment agreements, international investment agreements. And right now, we have to also look at the fact that that could be a problem right now post-COVID-19, because investors will not be thinking of the pandemic in favor of the state. They'll be thinking of the pandemic in favor of their investments. And they'll be probably looking at some tacky clauses like expropriation, fair and equitable treatment, because if a country, our borders were closed for 5-6 months and no work, what happens to their investments at that point in time? Those are the issues that will probably come to mind. So in post-COVID-19 international law, we should also consider that as an aspect. And it's important that we begin to think in that line right now, so I would not be taken unawares, especially for developing countries. Yes, like what Prof said earlier on, Professor Kafo said, at this point in time, everybody is affected, but the level of impact would vary from state to state or country to country. And we know that the level of impact on developing countries will be far more than developed countries, in quotes, probably because of structures that have been on ground and probably because of how things have been for the developing countries prior to now. So that is an area that should really be looked into. Prof also talked about the area of the Africa Continental Free Trade, the AFCFTA. Well, in principle, yeah, if you look at the rules of origin of AFCFTA, maybe if we're not careful, we may, what was supposed to be a very good deal will end up being not too good for the continent. But if we look at it from the holistic perspective, what was the spirit behind the negotiations of the AFCFTA for Africa? It was to help to develop our trade and services in-house and also investment in-house. Because as of last year, there was the statistics proved that we had over $3 billion floating in trade, you know. And if that were to work within our continent or our region, I believe it will help us, you know, to develop, because it's time for us to look inwards. One of the things, yeah, international trade is a balance of, international law is balanced between state to state. But in reality, will we really strike a balance? We can look at that. Will we really strike a balance? So when we know that we may not, some people like, I think it was Prof. Elias, I was saying something. If someone wakes up one day and decides that a state decides to pull out of WHO, another state decides to pull out of UNCTAD, another state decides to pull out of climate change, another state decides that, oh, okay, it's we don't want to do having to do with human rights. Most of these probably these treaties were signed because of the effect 90% of times on the developing countries. And Africa is a huge chunk of that. So when we're looking at the AFCFTA, I think we should also look at it and try to see how we can develop what we have to make it better for us. The loopholes are things that we can look into and try to lock up and try to knot and try to cover up so that we can enjoy what we have and make it better for us as a continent. And that's an aspect I was thinking of post-COVID-19. It's something we should also look at, probably pushing and developing further. You know, and that's that. I'm sure my 10 minutes is almost up if it's not up yet. And then would say, okay, trying very hard to rush to try to see how much we can put down before we move on. I also want to look at the other aspect of this discussion, which is what area, the future of international law and the skills required. For me, I'll give myself as an example. I got into international law about 11 years ago, but without training. I graduated from a Nigerian university, and just all through my working career, I didn't think of international law until I had to work in the Department of International Comparative Law in the Federal Ministry of Justice. I didn't have any training when I got there. So should we say 80% of what we got into was like root shock. You have to go back, read books, go online. It's more of like self-help. So what would we do now to assist students in the university? I have chats with them once in a while. Did you do international law in your school? Many of them tell me it's like probably, so it shouldn't just be like the way we have company law as a major syllabus. We should have courses like human rights as a major syllabus. We should have courses like investment, trade and investment, probably you can merge it, or probably take WTO as a major syllabus. And then take maybe investments as a major syllabus, sustainable investments as a major syllabus. The SDGs, take them as major courses, not just, you don't leave us to time to determine who will be, because it's something that we need. International law is the bane of existence. Let's be sincere, you know. So we need to develop things like that. So for students who want to come out, or those who are out and want to be better in international law, I would say one of the skills we should develop is negotiation skills. Because whether you're working for government or whether you're going to be employed by government to speak on their behalf at international fora, you would need a level of knowledge of negotiations. How do you negotiate a treaty? How do you pass your point across? How do you get the party to agree with you, your opponent to agree with you? These are things that we have courses like that now, but we can put it in our own syllabus in school. Probably international moots, trials or something, you know, or mock negotiations, things like that. It will help develop that skill. Then we should also think of international relations, even if it's not law, international relations, things like that will help develop us. And then we should not forget, there are areas of law that we do not, we forget to lay emphasis on, which was what Prof was trying to say, that most people who come to the school or come to asking questions are talking about just human rights. We have the international law, we have maritime law. It's a very important aspect because we have the new area of law that is coming up in the international waters. They are negotiating on matters beyond national jurisdiction for biodiversity. It's a very new area. I'm negotiating it, but I'm negotiating it with books. there are people who are already experts in this field. They've been there since 91, they've been there since 94, you know, and then I'm there looking, I'm trying to flip through their materials to get to discuss with them. So these are things that we should also look at. Maritime law is an area of law that we should deal with holistically too. Thank you. I'm sure I've done more than 10 minutes. So I think the rest will probably be left for questions and answers. Thank you very, very much.
Thank you very much. You have indeed done more than 10 minutes, but some of it was due to your loss of network at some point. Thank you. Finally, may I now call on Yusuf Dami, who is the Senior Legal Officer with ECOWAS in Abuja.
Good afternoon, the President of the International Law Association Nigerian Bar. I'm very happy and delighted to be here to make this presentation. I think one of the benefits, when you are the last speaker, I think you don't have much to say, particularly when you have the caliber of persons that have already done a good job. I want to thank the previous speakers before me, particularly Professor Obiora, who gave the keynote address. It's been a long while that we met back at a conference. Without much ado, I think I'll go straight into the discourse. Most of the things have already been said, and some of the things I wanted to say I've been thinking, but that will make me to go to another route in making this presentation. I think I'll be very direct. The first question was for this discussion panel was the future of international law and the skills required. Let me state here that the future of international law cannot be predicted. Certain trends, certain events in our world today are shifting the stakes of into the international order as we have it today. We know that prior to COVID-19 pandemic, the current international order largely constructed by the US in the aftermath of the World War II, though still very much in evidence today, for the basic reason that most states appreciate the benefits and therefore abide by its rules. And with an understanding that at the time, the US will retain sufficient power and influence to enforce compliance. But is this the reality of the present day? The answer will be no, because we have situations where the global distribution of power is exactly shifting with the rise of new powers, as well as influential non-state actors such as multinational organizations and transnational terrorist organizations. And you will see from current events that the US, of course, is growing more reluctant to bear the cost of world leadership, especially when it comes to the use of military force. And of course, you have strong power blocks like the China, Russia, and of course, even with lesser regional powers who have taken advantage of this situation in recent years to assert their own interests, thereby undermining certain aspects of the international order as we have it today. Now, these actions have negated the norms of international order with, I'll say, a serious price, a serious price, which may have demoralized others and in fact, in some situations, embolden certain detractors. Now again, coming to COVID-19, we all know that not just COVID-19, but any global pandemic such as what we have now poses serious threats to international order due to, of course, scarcity of resources and, of course, environmental degradation, which of course continues to grow. Invariably, the benefits of the current international orders we have, in particular in many international agreements based on the concept of free flow of goods, services, ideas, and people no longer look promising as a result of livelihoods which have continued to suffer as a consequence of the pandemic. So no doubt, the impact of COVID-19 is evident, particularly in areas of international trade law, international investment law, and others, which of course invariably impacts on the international law. And I'm happy that during the keynote presentation by Professor Obiora, he mentioned the need for a more robust international trade regime. Now, coming to the consequences of the COVID-19 and the skills required. Firstly, let me state this, that states, through their foreign relations, contribute to shape international law. And we know that this COVID-19 posed a very serious problem, not to one state, but all states, and invariably the humanity. And I was very happy with the statement of Professor Obiora when he said that it cannot be resolved by one state alone, but it will end with all states, not just one state. And this is a concern when you come to international law, dealing with international solidarities and what have you. We know that we've seen very strong nations which we thought were very powerful in terms of almost everything, but at the COVID-19 crisis, they reached out to other nations and were soliciting for help. And this is a pointer that to the basic fact that one state alone cannot survive on its own. And that's the importance of international law in this regard. I wouldn't want to go into all that because I only have 10 minutes, so I'll go straight to the skills set. And I've listened to the previous speakers before me. They have mentioned quite a number of skill sets, and they have advised lawyers and even law students on certain skills that are very pertinent to a practitioner in the branch of international law. But I'll just be coming with a little more add. One of the most important impacts of COVID-19 is that the workspace as we have it today, whether law, whether medicine, whether anything, has been trusted to the part of technology by default. Now, technology is very important in whatever you do. This is very important, and this is my very most important advice to students and even practitioners that don't take this thing seriously. As an international practitioner, legal practitioner, and even to survive this post-COVID-19, technology is key, whatever you do. And you'll find out, let me even surprise you, there was a program just some days back on the radio, and I was amazed. And they were talking about this technology, and the stats showed that we have 23% of doctorate holders in Nigeria who are jobless. And you had states that had very high employment ratios. But surprisingly, probably because of technology and their vocations and all that, let me give a state like Anambra State, that the employment quota fell drastically to about 17%. That shows you something. Something is being done. In the COVID-19, it's not just enough to have your knowledge or your skills. You must, impute technology with your occupations or your vocations. And this is a very important aspect in this post-COVID-19. The world has changed with the impact of COVID-19. The world will never go back. And I think technology will continue to drive a lot of economies, a lot of studies, and a lot of professions and the legal profession being warned. In fact, in the ECOWAS Court of Justice, just some few months, we started having court sessions post-COVID-19 lockdown. And one of the first things that the Court of Justice did was to actually produce another practice direction. In a new practice direction, if you don't know much about using electronics or gadgets or pieces, you can never practice before the court. For your internet, for your PCs, and you must have certain computer skills for you to effectively come before the court. And this is a very important one. Another thing I would like to note here, just like what Professor Obiora and Dr. Elias said, it is very important that for all lawyers, it has always been actually reiterated, even in the law school and after the law school, by senior principals and partners and all that. You must, as a lawyer, be very knowledgeable in the field in which you want to go. Without having a requisite or full knowledge of the subject matter you're going into, you will run into problems. And this COVID-19 is coming up with new trends. And that's why lawyers must be knowledgeable in actually being very apt when it comes to the new trends that are coming up with this post-COVID-19. I was very happy when Dr. Elias was pointing to dispute settlement and for resolving disputes. And he also mentioned a very key thing when it comes to force majeure. I think the principle of force majeure will come in to be a very consistent concept or defense when it comes to a lot of issues or cases that will arise as a result of non-performance or failure to perform obligations under international contracts and even domestic contracts. So it is very important that in this post-COVID-19 era, I think lawyers and even students that are listening must be apt when it comes to being knowledgeable with all the new trends. It's not enough to know the legal principles that you've learned in school, but you must keep up. You must be abreast with all the new trends happening in the world. When Professor Obiora was talking about this knowledge, he mentioned the AFCTFA, and he cited an example that Nigeria, being the largest economy in Africa, might be in jeopardy, particularly when probably foreign countries might come to dump goods probably in another African country, and it might spell doom for Nigeria. And this was a very good issue that he had raised, because in the ECOWAS where we belong, we have 50 member states. That's the West African, in the West African region. These 50 member states, we have a law which is also an annexure to the ECOWAS treaty. It is the ETLS, the ECOWAS Trade Liberalization Scheme. In essence, what this scheme does is that, yes, you're allowed to produce anything within the West African region, the ECOWAS community, and once the goods that are produced in this member state, you are free to move to other ECOWAS states and sell your goods. But one catch there under the ETLS is that the raw materials that you use to produce those goods you wish to sell under the ETLS scheme must have been produced in your country, in Africa. We had a similar case like that in the court and even in between two countries, whereby a country produced tin tomatoes, it was packaged, it was produced in this country, and everything stated it was produced in the member state country. But when it came to Nigeria, Nigeria refused. But it was discovered that the raw material that was used to produce the tin tomatoes did not emanate from the member states. And this was a dispute, but it was resolved that it couldn't have been a product intended for the the ECOWAS trade liberalization scheme, because that was not the essence. I think this is where knowledge will come into play, because I think the sole benefit of the AFCTFA is that countries in Africa, and just like what we have in the West African region, will of course grow their own products and produce products that will come out of the raw materials that are given. Another aspect that I want to point out is negotiation. It is very key under international law. Negotiation is always a skill that will be applied in whatsoever you want to do. And I think it is very important that lawyers and law students and people of like mind should be very, very conversant with the skills of negotiation, which is very important. The last aspect I would just like to point out, which is also key, and I think particularly since this is the Nigerian branch of the International Law Association, I think I would just want to relate it home. It has to do with language. You cannot, in the modern times, want to be a practitioner or a player under international law, and you don't have knowledge in foreign languages, or you cannot speak a second language. I think it is really going to make such a person or group of persons very vulnerable. For example, in the ECOWAS, we have three official working languages, which is English, French, and Portuguese. And if you are going to be employed in the ECOWAS now, it's becoming increasingly requested that you should at least have knowledge in two of those languages. Now, under international law, we have a lot of, and I'm relating it back to Nigeria, we have a lot of Nigerians that do not have the benefit of speaking other languages, and really it's not their fault. And I give you that instance. If you look at the Francophone countries in Africa, English is compulsory, and you must write and speak English to a certain level. So they have an advantage over us when it comes to languages and all that. And I think this is where I think even international law education should try to emphasize or try to develop that foreign languages are important. And I would like to just close here by saying that I agree absolutely with what Professor Obiora said, because it is my belief that disputes will continue to happen and disputes will continue to occur. But what is most important under international law, and I think the concept of international law, is the joint international solidarity. And this is important. This is an important dimension for conflict management, which definitely will bring about conflict prevention. I would like to stop here, and I want to say thank you again to the organizers for giving me this opportunity. Thank you very much.
Thank you very much, Mr. Damadami, for your very concise and excellent presentation. We've now heard from all our panelists, and the next session is the questions and answer session. We're going to take a few questions because although we're running slightly behind our schedule, just about 20 minutes, we do have some time for questions and answers. Anyone who wishes to ask a question should please raise his or her hand. I think this is the point that Mr. Ramadan made about being technology savvy. So if you're on this platform, you see that there's a way you can raise your hand and we'll see it, and the host will unmute you to allow you to ask your question. Are we ready? Right. Who is going to start the questions?
In the meantime,
Assume that.
I see that a lot of
Yes, sorry.
some questions have been put in the chat, and I can just read one or two of them while we wait for people to raise their hand electronically. The first one from Professor Olabisi Akinkugbe is, my question borders on the uncritical way in which international economic investment law courses are taught in our universities. I heard Ms. Eva speak to this gap and was wondering what your thoughts are in respect to enhancing this aspect of curriculum delivery in Nigeria. And a second question from Tetevi Davi, which again, all the panelists can feel free to chime in, but I think this is more for Professor Kafo. She's asking, Tetevi Davi is asking, my question is, should the African Union and regional economic communities be using their statutory powers to a greater extent, sanctions, etc., to enforce compliance from states who are violating their human rights obligation during the pandemic? And I'll read a third one before I mute myself. Adekunle Abiono is asking, in light of the COVID-19 situation, how can states justify the imposition of gathering or traveling restrictions without any universal standard on what kind of restrictions are suitable? Over to the panelists.
Right. Okay, let's, Professor Kafo, would you like to address the last question, the one from Tetevi Davi?
The one on the compliance?
The one on the extent to which the regional organization should use their powers to sanction violators of international human rights.
Yes. Oh yeah. Well, yes, of course. The texts of treaties, instruments, agreements adopted by these organizations allow them to. And of course, in Mali, they've already done so to an extent. They've at least commenced the processes. However, of course, as students of international law and relations, we understand that there's more to it than what the text allows, and simply imposing sanctions. There are questions of power relations. There are questions of to what extent you actually have the capacity to pressure the state enough to comply. And there are tensions with sort of with the popular will in the country itself, right? So, and this is what we call the democratic deficit sometimes. So, on the one hand, states have these international obligations, but on the other hand, locally, local democratic popular sentiment may not align with what the rule is, right? So we know, for example, in Mali, to use as an example, that such changes of power are illegal, simply, under both the AU regime and ECOWAS regime. However, I don't know the extent to which that is actually the popular sentiment on the ground, and there will be a tension there, right? So, my own view is that such changes of power are illegal under international law, and of course that these organizations are well within their authority to impose sanctions.
Thank you very much. Professor Akinkugbe's question is about the curriculum. I think it's a more general question because all the speakers, at least two of our panelists, referred to the deficient nature of the curriculum, especially Moteshe Eva, mentioned the poverty of the curriculum, but also also mentioned the poverty of the curriculum at as why is it that Nigerian primary and secondary have not made a foreign, a second language compulsory? For example, French or German or Mandarin, the way that most European and North American schools have. So that's just a continuing trend of very deficient curriculum. But if any panelist has further views to express in relation to that, could they signify and make their comment?
Sorry, Professor Odita, if you don't mind, if I could just intervene a little bit. I asked the question, and I think Dr. Elias was nodding me privately to intervene. So I should say that thank you very much for this organization. That it's a conversation that I think it's timely. I think it's critical to have these conversations on our own terms and to be able to put in perspective the sort of issues that we need to be addressing. Some of which have been so poignantly put by the panelists. But I think the question of curriculum design and teaching in Nigeria is one that really needs the most urgent intervention, amongst many other things. And I say this for some reasons. I am one of the editors of Afronomics Law Blog, which over the past year and a half has become a space for a lot of scholarship on international economic law in Africa and the Global South. And the sheer perspective of views from the audience, which we're particular not reaching out to established scholars. So it's not the Professor Lawis that we want every day, because we know they do the work that are out there and are celebrated. But we want a young graduate scholar from University of Ibadan that has an excellent, graduate program to be put in conversation with people abroad. So questions of access and quality writing are those that have been at our heart in those places. And it is where I think that, our professors in our universities in Nigeria are doing their best. So this is not a knock on the professors, but there's a challenge, there's a gap. The recent call that Afronomics Law has, I'll give this an example and then make the last point and yield, was for the teaching and research of international law in Africa. It is unfortunate, there is no submission from Nigeria. Not one submission from Nigeria. People from the Global South and Asia have written, Kenyans, South Africa, Ghanaians have written it. And so there's that gap in terms of how much we're really doing to encourage, one, these young graduates to write. So, and I think in this regard, the law reviews of the universities are in a different age. Credit should be given to them. And I think we could encourage them. Two, how are we putting materials that Professor Kafo and others have written in their hands? And so on. Critical approaches to international law. Okay. How do we support the teachers as well? I think these are core things, practical aspect that will corroborate some of the efforts that Mrs. Eva has identified in terms of just moving forward. So it's not a knock, but I think at some level we have to be realistic about the fact that there's a gap in the knowledge production. And if history is not brought back to understand the impact of colonialism on our curriculum design, is unfortunate. We may not be able to get to that place where we want our students to appreciate that international law, investment, trade, arbitration should not be taken hook, line, and sinker. We have to question its relevance for our own society. Thank you.
Thank you, Professor Akikubu. I think those observations are well made, but if I may add, the problem of deficient curriculum is a pervasive one. It's not limited to international law. I remember a few years ago, I was a keynote speaker at the Conference of African Deans of Law Faculty. And one of the things that I spoke about was the very deficient curriculum of Nigerian and perhaps other African universities, because I took as an example what I met when I came to University of Lagos in 1981 and compared that with what they were teaching 30 years later. And there wasn't much difference in terms of structure and content. Whereas when I compared that with my own experience at Oxford, over a period of 10 years, I noticed that the Oxford curriculum had changed dramatically. So I don't think that one should exonerate the teachers and say, well, it's not their fault. I actually think it's their fault. It's not the fault of the government to design a curriculum for a law faculty. It's the fault, it's the responsibility of the teachers, both in terms of to develop new areas of law, and also even trying to alter the content of the existing areas that they teach. And when you look at the reason why handouts are very popular in Nigerian universities is that you can go back and see that some of the things that the professors said 20 years ago are the same things they're still saying now. So why do you need to attend the lecture? You just need to get someone else's notes and to copy. So that has to be laid at their doorstep. Secondly, the fact that there is a declining culture of law review publication is also the fault of the lecturer. It's not, we know that Nigerian universities are constrained financially, but today there is perhaps more information than 20 or 30 years ago. A lot of materials are available online, and there are a number of open data sources which are available. Where are the Nigerian law reviews which can compete even on a regional basis? I don't see them. Even as an academic, as a practitioner, you want to find out what Nigerian law is or what commentaries there are in particular areas. You find that most of the commentaries are by very busy practitioners who have done maybe a 6 or 7 page. So we should call a spade a spade. And I think a lot of the responsibility for the problems that the speakers have highlighted development must be left with the teachers. It's their fault. I don't see who else can reform the curriculum. Right. Professor Lawi, are there more questions from the chat?
Please.
Yeah,
I would just like to. Okay.
There is one from, yes, someone was trying to say something.
Yeah, I was trying to just add to what, can I go on? Okay, thank you very much.
Yes, you can.
Mr. Auditor, I thank you very much for your clarifications there, in as much as I also sympathize with Mr. Olabisi. But I would like to say something here. Charity begins from what? From home. We have our community laws, and we found out in the ECOWAS, and we've been having sensitization workshops and all that over the years. We found out that universities were not even teaching our own community laws. So if you don't teach your community law, how will you teach the international law? And this is the point I wanted to even ask Mr. Olabisi directly. Is the Afe Babalola University teaching the ECOWAS community law? Because you know, last year I know we went to University of Lagos, Lagos State University, and they have commenced teaching the community law. ABU Zaria, I think, was the first, and we have some in the East. But it is very important that the faculties of law of our universities start teaching our regional laws. And it is only when you start doing that that you can go. But when they do not know anything about their region and they're expected to practice there or where their practice is, I think you're making them very vulnerable in times like this. Thank you very much.
Thank you very much, Mr.
Yes.
Dami. Yes. So I will read the two other questions. I think one is asking from Jacob Sule, is asking about how younger lawyers or students can leverage on experiences and network of people like Mrs. Eva in order to acquire additional experience that will make them globally competitive as Nigerian graduates. And the other one, I guess, is for Mr. Yusuf, which is a question about how to learn more. How can I get further clarifications on negotiation in international law? And that question is from Chi Amaka.
I answer?
Yes, please.
Okay, thank you very much, Chiamaka, for that very apt question. As I said, in modern trends, when it comes to international law and practice, I think negotiation is a very, very important. And that question, it's not, negotiation is not something that you just, it's something that you learn, and it's something that you are taught. It's something that you practice. And I'll leave it at that. But I think that there are very good opportunities that you could get very good knowledge about negotiations when you probably, I don't think at the undergraduate level they have such courses. But I think at the postgraduate level, particularly with the branch of law in which you want to go into, I think you have such courses, and I think you get very good knowledge from faculties or for professors or learned scholars that have given. You can start reading certain books. There are books that are available. Even now, you don't have to wait for that opportunity. There are books that are available online. There are books that are available in libraries. I think you can get them and start, getting used to the terms and getting used to probably the skills, and you learn one or two things before that time comes. Thank you very much.
Yes, thank you, Mr. Who was going to speak?
Okay, that was Omotese Eva.
Omotese, yes, please go ahead.
Yeah. Based on the question that was asked, I hope the academia does not see me as being too aggressive in my presentation or discussion, because the truth is this: it's rather unfortunate. Like we said, this is for Nigeria, ILA for Nigeria. So we'll be talking from our perspective. It's rather unfortunate. Most of us get into our workplaces without requisite knowledge of what we're to do. Every lawyer is trained in basics of criminal law, civil law, company law, and the likes. Now, a law student is not trained basically on international law. And it is unfortunate, because international law is a growing trend. And the truth is, without international law, some of our colleagues, like you, Professor Elias, would not be where you are today. You are not practicing in Nigeria. You are not doing the basic criminal law practice or the basic civil law practice. You're doing international law practice. Like I said, many may not have the opportunity to go to Oxford University. Many may not go to Cambridge. Many may not even have the privileges of having to pay for some courses online. So why don't we have it incorporated? This is for our law teachers, seriously. Have it incorporated in our curriculum. And I think we can, Professor Kinkukbe, we can have it incorporated in our law curriculum back at home. Before I came to my current posting, which is legal advisor of where I am now, I was in my international law department, and I was privileged to interact with law school students. And of course, in my interaction and in my coaching, I would ask, the first question was, have you done international law before? And I found out that students who schooled outside the country had done international law, but students who schooled in Nigeria had not done international law. And it's not a fair footing. They're going to the same market tomorrow. They don't have this fair footing. Yes, it's true that we can read on, I am a product of self-help. And I met an international organization that's not even Nigerian based, but they work with developing countries, and they helped me free of charge at no cost to my government. But how many people will have the privilege of meeting such organizations in life? Yeah, you can download some of the material, but when you are taught in school, it's different. At least you have the basic information. So it means that you have your UNCLOS, you have your, if I say UNCLOS now, I'm sure maybe a few of our students don't even know what UNCLOS is. So you have your law of the sea. You can develop that on your own. But when you have the maritime law being taught to you, the way your criminal law was taught to you, you now understand what it means when you say, okay, there's infringement, or there's our territorial waters are being was infringed upon, or things like that. You have a better understanding. You can work better. But when if we wait for it to come from our workplaces, we may not help us. But if we, as law teachers, can sit down and say, okay, even if our law teachers do not have the requisite knowledge of international law, we have people we can leverage on. We have our law teachers outside the country that are in these good universities, like Professor Okafor, like you, sir. We have you that we can leverage on. We can sit back and say, okay, can we incorporate this into a curriculum? Like what our colleague from ECOWAS is saying, we don't even, the basic regional laws, we don't even know them for our sub-region. And it shouldn't be. So that's why I think that these are things that we can, as Nigerians, do to improve our curriculum. Leonard Silk, or QC, was saying that in his university, 10 years, and you see a change in curriculum. But if I go back to my university, I left university, I'll see much of a change, and I will not still see international law like that in my curriculum. So that's what we're saying. It's something we can work.
Okay, well, it looks like
together. That's this we have the academia and all of that. So thank you. I think I've spoken a bit too much. So
well, you have represented your presentation.
Something.
Yes, thank you. I think it's fair to, in defense of the academics, it's fair to say that you cannot be taught everything in a 3 or 4 year law program. So you either have to do postgraduate so as to access some of the specialized subjects in international law, or you have to teach yourself. I, for example, I did not study public international law at University of Lagos, or even private international law, but I had to do those along the line because I felt I needed them. So people can also teach themselves. The universities cannot teach everything unless you want to make a university program 10 years as opposed to 3 or 4 years. But the point is well made. I think the curriculum is very deficient, not just in international law or international maritime or international environmental law or arbitration. It's across the board: contracts, tort, criminal law. You be amazed with students in Nigerian universities today. And of course, it's a disaster that the constitutional law course itself not incorporates any aspect of regional institutions the way that most European curricula do. Introduction to EC law as part of their basic constitutional law. But there you are. All right, I think, Professor Lawi, is there any more questions that we have? I'm also looking at that.
Yes. With your kind permission, Professor Dita, sir, I will just read out two more questions, but I think we'll probably take the approach of letting our panelists just say their final, closing remarks in answering those questions. And I would also welcome Professor Akin Kugbe, who said he would like to contribute as well to, when going for the final round, he can also intervene as well. One of the questions which I think Dr. Elias might be able to answer is about how can Nigerian law students get access to international law internships in order to develop their skills. A second question is for Professor Odita, because it is about the ILA. And the question is that what is the ILA doing in terms of helping students to gain knowledge? I guess students that want to access ILA programs must be members, and they would be able to see what we're doing. But I'll leave it to Professor Odita to take that one. There is a question from Mr. Abiona which has not been answered, and I guess Professor Okafo can talk about it in terms of this whole traveling restrictions when there are no universal standards. That should that really be the norm? Are we missing some in that regard? And there is another one for Mr. Yusuf Damadami, which is about states through their foreign relations contribute to shape international law. Would you say that Nigeria's foreign relations among West African countries, as they are, would give us a lead role in the formulation of international law? And that's from Queen Esther Ogu. I would hope that with Professor Odita and the other speakers can take these questions one after the other. Thank you.
Thank you. Did you want?
All right. Let me invite. Let me invite Mr. Damadani to take the last question, and then other panelists to take one or two more questions before I round up with the one concerning the ILA.
Yes, please. Thank you very much. I think I will just be very direct with this. In West Africa, we have a population of about 250 million, thereabout, and Nigeria has a population of over 100 million out of the 15 member states. And just like have been rightly said by Professor Obiora, we have the largest market in Africa, and you can imagine the strength of our military here. And of course, not to talk of our resources in West Africa. So yes, the answer is yes. Nigeria, whether you like it or not, has a very big role to play in West Africa. And I think the voice of Nigeria is one that cannot be toyed with in West Africa. If you remember that there were democracy disruptions in Republic of Sierra Leone, and it was Nigeria that installed democracy back in Sierra Leone. If you go to Liberia, you found out that there was a civil war there, and it was the ECOMOG that stopped the civil war and brought back the country to, constitutional order. And 80% of the soldiers that did that operation were Nigerians. So whichever way you go, you'll find out that Nigeria is always playing a key role in West Africa. I think our relationship with other West African countries in view of the visions of ECOWAS has made Nigeria to stand out, and to it has ensured that Nigeria is not just Nigeria plays a very important role even in certain aspects of the ECOWAS and in their country. So I think we've done very well in West Africa, and we're doing very well in Africa. And yes, Nigeria will continue to play such roles. Thank you very much.
Thank you. So we have the question on the travel restrictions, and I see from the chat that allied to the travel restrictions has asked about the issue of data integrity. But it's not very well to ask people to provide this information, provide that information when there are differences in the levels of data protection laws that exist in Nigeria and perhaps other countries. Yes, who would like to take this? Professor Kafo, would you like to take this? And I have one more for Dr. Elias after this.
Yeah, thank you, Professor Dita. I think I can take the aspect on the travel restriction better. let me put it this way: the international health regulations are squarely deal with that topic, right? That's what they're about. They already envisage such situations, travel restrictions. That is why Nigeria and South Africa often spat over yellow card, yellow fever vaccinations, and all that. That's not just, it didn't come out of the sky. That comes from the health regulations, international health regulations, latest edition 2005. Was it 15? I think 2005. And so that imposes a regime on all states. There's actually a regime that tries to harmonize, provide similar standards across the world. How those standards are implemented differs, of course, as you can imagine with any global regime, right, by specific states. And so travel restrictions do have the international legal basis. They do have, I wouldn't say uniform, but fairly uniform, at least at the high level, set of standards that states have to aim to comply with. So in terms of the details, international law does not necessarily get into sort of the granular details and say, you only allow 10 people to gather 100. You have to allow a margin of appreciation to particular states to implement these regulations, which are necessarily broadly framed, right, to allow some scope of discretion to the states that apply them. But there are regulations in existence as we speak. And just very quickly, just to chime in half a second on the very interesting, compelling, and I completely agree with everything that has been said about the curriculum. I sort of mentioned it. I didn't have time to develop it in my presentation. I think the curriculum is simply, I agree with Professor Odita, it's simply not fit for purpose anymore. It's, it's static. We know why. Our universities have been defunded. I mean, this has driven out talent. Let's be very honest, because we are among ourselves, all right? We're all products of these same institutions. It's not as if I was trained on the moon. I mean, I was trained at the University of Nigeria. I left there when I was 26 as a lecturer. So I was formed there. So these were high quality institutions. They have been defunded. I used to read International and Comparative Law Quarterly, a week after it was published in London. In Enugu, I wasn't even in Lagos, right? Who does that? But now with electronics, you can begin to bridge that gap, I think. And then just very lastly, I talk too much. Lastly, I think that many universities are moving to a compulsory transnational law course. By transnational law, I don't mean just international law, but regimes like ECOWAS that are not purely international, they traverse the international and the domestic. ECOWAS law, people don't even know, is immediately applicable upon signing by the heads of states. How our courts have not even begun to grapple with this. What does this mean? A Ghanaian court ruled on it recently, the first case in West Africa, and we're beginning to, even I am working on a paper as we speak, trying to understand what that might mean, and so there's a lot of very interesting issues, as Professor Dita said, that, we're teaching our domestic law as if it's unaffected by these already transnational regimes, right? So there's a need to equip our coming students with a compulsory basic transnational course that you can teach in one term, that just gives them the basic concept. Tell them there is such a thing as ECOWAS, and it has these regimes. You don't have to get into any detail. And you whet their appetite and they can take it up at postgraduate level. Yeah. Sorry I took too long.
Thank you very much, Professor. Right. Finally, Dr. Elias, one of the participants has asked us how can they access opportunities?
Thank you very much for that. It's a good practical question. And again, I'll dial into what has just been said by Professor Okafor when he mentioned resources that we can use online. I think part of any change to the curriculum, I think this could be an annex to that, in the sense that certainly on this forum, I know many people, up to 5 or 6 people in this listening, I've seen their name for the internships. So people need to get funding from private sources. But that's the UN. There are many international organizations talking pertinently now. I know the WTO, for instance, has it's a competitive internship program, but it's there online for people to apply. So I think making good use of what is online is out there. I think, like I said, very, very simple. Any organization that you know of, there will be a page on their website talking about vacancies and things like that. Internships will be there. I know that in the different organizations I have worked, that has been the case. Like I said, I just did a search on Google just now saying UN jobs, internships. They're in the hundreds. As I said, not all legal, but they're in the hundreds. So I think making use of the internet is, it's so simple and it cannot be overstated. We'll start there for sure. Thank you.
Thank you very much. I'll just take the final question, which is how can the ILA help with students who want to gain knowledge in these areas, as well as, I think there's another one by Jane Ezirigwe, who is asking whether it is possible for the ILA to act as a platform for diasporians to impact knowledge of international law on our younger members. I'll just take those two together. Professor Olawoye has already answered this in part. The first stage for the young members trying to access knowledge of these new and developing areas of international law is to join the ILA. I think for students, and indeed for everyone, joining is very straightforward, very cheap. In terms of developing curriculum, the ILA is also looking at that. And indeed, I think in July this year, last month, we were supposed to hold a 1-week residential masterclass on different areas of international law. But unfortunately, in association with the Nigerian Institute of Advanced Legal Studies, but unfortunately, because of the COVID-19 pandemic, that program had to be aborted, and it simply wasn't feasible in the time available to organize a masterclass over a 1-week period. And so we'll find time and reinstate that. In relation to getting diasporans to come and share their knowledge, I think we're doing that at the ILA. Indeed, most of our programs involve bringing one or more of our own diasporans to come and speak. Today we have at least 2 of them, Professor Kafo and Dr. Elias, and we'll try and do more. But as a matter of urgency, we're going to try and liaise with the law faculties of Nigerian universities to see how we can discuss the curriculum content with them and to help them to make their curriculum more fit for purpose. So those are my answers or responses to the questions asked. I think we have run out of time. We have enjoyed this. I have personally enjoyed this very much, and I would like to call on Professor Olawoye to make some closing remarks, and also to call on Johnson Agu, our secretary, to give a vote of thanks.
Thank you very much, Professor Dita, QC Senior Advocate of Nigeria. And thank you to all the wonderful panelists and speakers. It's been wonderful. I just want to add that for those that want to contribute to the work of the ILA, the Nigerian branch is always open to you to join us. It's like Professor Dita mentioned, this is almost like the cheapest organization that I know of in terms of the fees. I think student membership for 1 year is just 5,000 naira or something like that. And given the quality and the amount of people in our network, it's surely value for money. And for students wondering about network, because I think Jacob Sule asked about networking, I think joining your epistemic community is the starting point. Your epistemic community is the network of people you wish to be like in the future. And so if you want to be an international lawyer, then you start with joining the ILA at every event, at every conference. Even last year when we had our physical conference, we sponsored students from all law faculties to join us and allowed them to interact. I think meeting Professor Dita, meeting Professor Kafo, who is also a member, and meeting Dr. Elias and many of us that are involved will be a starting point to become a future international lawyer. So check the website, email info@ILA Nigeria and become a member. Over to the Secretary General of the ILA Nigerian branch to give the vote of thanks.
I think our team has thank you personally for calling on me to thank everyone on behalf of ILA. Indeed, ILA is very grateful to everyone who has found time to create this occasion where a resource person or as member of the audience. Particularly, we are grateful to the resource person, the keynote speaker all the way from Canada, Professor Kafo. Yes. We're also grateful to Dr. Dan and Mrs. Omoteshu Eva. We can't indeed thank you well enough, but actually have found time to create this occasion. We wish that every other thing you need, find time to keep on the progress you need. Indeed,